Just when you thought the drama surrounding the former president couldn't get any more explosive, a New York courtroom dropped a bombshell that sent shockwaves through American politics. We're talking about a civil fraud case that exposed decades of alleged deception, valuations inflated by thousands of %, and a financial empire built on what prosecutors called systematic lies. The shocking revelations coming out of this case aren't just about one property or one questionable deal. This is about an entire business model that allegedly relied on bending the truth to breaking point, and the evidence prosecutors uncovered is absolutely staggering. Let's dive into what really went down, because the details of this case are wild beyond belief. For years, the Trump Organization operated as one of America's most recognized real estate empires. Properties bearing that famous name dot skylines from Manhattan to Florida, golf courses spread across multiple states, and the brand itself became synonymous with luxury and wealth. But behind the gold-plated facade, prosecutors claimed something far different was happening. The investigation kicked off back in 2019, when New York's Attorney General started digging into how properties were being valued. What they found wasn't just questionable, it was allegedly fraudulent on a massive scale. According to court documents, the same properties were being valued radically differently depending on who was asking. Here's where it gets absolutely insane. Take Mar-a-Lago, that famous Palm Beach estate that's been the center of so much political activity. Court records show it was valued on financial statements at anywhere from $426 million to over $700 million. But here's the kicker. The Palm Beach County tax assessor put its value at just $18 million to $37 million during the same time period. That's not a minor discrepancy. That's inflating the value by over 2,000% according to prosecutors. But wait, it gets even more outrageous. The property had deed restrictions from 2002 that limited its use to a social club, not a private residence. This restriction significantly impacts value. Yet financial statements allegedly ignored this completely, valuing it as if it could be sold as an unrestricted private home. And Mar-a-Lago wasn't alone. Prosecutors presented evidence of systematic overvaluations across multiple properties spanning over a decade. His Trump Tower penthouse, court documents showed it was valued as being nearly 30,000 square feet when it was actually around 11,000 square feet. That's tripling the size and therefore tripling the value based on completely false numbers. The apartment was listed at $327 million in 2015, which prosecutors called absurd, given that at that time only one apartment in all of New York City had ever sold for even $100 million. Golf courses, commercial buildings, even his children's apartments, all allegedly valued using what prosecutors called fantasy numbers that had no basis in reality. The trial itself was absolutely explosive. Testimony revealed internal emails from bank executives who reportedly knew the valuations were questionable, but approved loans anyway because the fees were too good to pass up. One executive allegedly wrote that everyone knew the numbers were fantasy, but the potential profits made it worth the risk. Think about that for a moment. Even the bankers who had every incentive to believe the numbers knew something wasn't right. The case involved 40 witnesses, mountains of documentary evidence, and testimony that lasted months. Accountants took the stand, bank executives were questioned, and even family members had to explain their role in preparing these allegedly fraudulent financial statements. In February 2024, Judge Arthur Engeron handed down a verdict that stunned the business world. He found the defendants liable for fraud, ordering them to pay $354 million in penalties. With interest, that number climbed to over $500 million. The judge didn't hold back in his written decision either, saying the defendants engaged in frauds that leap off the page and shock the conscience. He specifically called out the Trump Tower penthouse overvaluation and the Mar-a-Lago scheme, writing that there was no legal gray area about the deed restrictions and that the valuations were clearly fraudulent. The judge also imposed other penalties: 3-year bans from serving in corporate leadership, restrictions on applying for bank loans, and the appointment of an independent monitor to oversee business operations. These weren't slaps on the wrist. These were designed to fundamentally reshape how the organization could operate. But here's where the story takes another dramatic turn. The case went to appeal, and after nearly a year of deliberation, something unprecedented happened. The appeals court issued a 323-page ruling that was so divided it required an unusual compromise just to reach a decision. In August 2025, the appellate panel threw out the massive financial penalty, calling it excessive and a violation of the Eighth Amendment's prohibition against excessive fines. 2 judges said the fraud finding was correct, but the penalty was too severe. Two other judges wanted a completely new trial, and one judge thought the entire case should be dismissed. In a truly remarkable move, the judges who wanted a new trial signed on to the opinion upholding fraud just to break the stalemate and allow the case to move forward to higher courts. It was a judicial compromise that legal experts called extraordinary. So what does this mean? Well, it's complicated. The penalty was thrown out, saving hundreds of millions of dollars. But, and this is crucial, the fraud finding itself was upheld. Multiple judges on that panel agreed that the evidence showed systematic fraud occurred. The organization was still found liable, just without the massive financial penalty attached. The Attorney General immediately announced plans to appeal to New York's highest court, meaning this legal battle is far from over. Meanwhile, the Justice Department under the new administration has launched investigations into whether the Attorney General herself violated civil rights by bringing the case, turning the tables in a way that critics call political retribution. The case reveals a pattern that legal experts say spans decades. It's not about one bad apple or one questionable transaction. Prosecutors presented evidence of consistent, repeated overvaluations across multiple properties, multiple years, and multiple financial institutions. Real estate experts who testified said the discrepancies were impossible to explain as honest mistakes. When you claim your apartment is 3 times bigger than it actually is, when you value property as unrestricted when you personally signed deed restrictions, when the same property gets wildly different valuations depending on whether you're seeking a loan or paying taxes, that starts to look like a deliberate pattern. What makes this particularly damaging is the systematic nature of it all. This wasn't creative accounting in a gray area. This was allegedly presenting completely false information to banks and insurers to secure better terms. The judge found that defendants showed a propensity to engage in persistent fraud, and their complete lack of contrition borders on pathological. Even conservative legal commentators who often defend the former president had trouble with this case. The documentary evidence was overwhelming, the patterns were clear, and the explanations offered at trial didn't hold up under scrutiny. The appeals court ruling, while throwing out the penalty, still found that fraud occurred. That's a significant legal finding that doesn't just disappear. It means that despite avoiding the massive fine, the finding of fraudulent business practices remains on the record. This case also highlights how differently justice can work depending on who you are. For an average person caught inflating property values to secure better loan terms, criminal charges would likely follow. Banks don't typically let regular folks walk away from fraud allegations with just civil penalties. But when you're dealing with high-profile cases involving major political figures, the system operates differently. The whole saga raises serious questions about accountability. If someone builds a business empire on allegedly fraudulent valuations, if they systematically misrepresent assets to financial institutions for years, what are the consequences? Is a finding of fraud without financial penalty enough? Does avoiding the fine mean the behavior was acceptable? These aren't just legal questions, they're fundamental issues about how our system handles white-collar crime and whether wealth and power provide immunity from consequences. The case isn't over. It's heading to New York's highest court, where judges will have to decide whether to reinstate some or all of the penalty, whether the fraud finding stands, or whether the entire case gets tossed out. That decision could take months or even years. Meanwhile, the business operations continue under the watchful eye of court-appointed monitors. The restrictions on corporate leadership remain in place during appeals, and the finding of fraud stays on the books unless a higher court overturns it. What's clear is that this case has already done significant damage to the claim of being a brilliant businessman. When your own accountants testify they were given false data, when bank executives admit they knew the numbers didn't add up, when judges find systematic fraud spanning decades, that's not the mark of business genius. The real story here isn't just about one legal case. It's about a business model that allegedly relied on deception, about financial institutions that looked the other way because the fees were lucrative, and about a system that struggled to hold powerful people accountable even when the evidence seemed overwhelming. Whether the penalty gets reinstated or not, whether appeals ultimately succeed or fail, the findings in this case have permanently altered the narrative. Court after court has looked at the evidence and found fraud occurred. That's not political persecution. That's the justice system functioning exactly as designed. The next few months will be crucial as higher courts weigh in, as investigators dig deeper, and as the full scope of these financial practices becomes clear. This isn't just about properties or valuations anymore. It's about whether anyone, no matter how wealthy or powerful, can operate above the law. One thing's for certain, this legal saga is far from finished. The stakes remain incredibly high. The evidence continues to be scrutinized, and the outcome will send a message about accountability in America that echoes far beyond one business empire. Stay tuned, because this story is only getting more intense.